Hello again. Today I want to continue the discussions about learning from your final closed memo. I'm going to focus specifically on the question presented in the brief answer today because they kind of go together. So let's get started. Question presented, time to learn. I'm showing my favorite slide because it just reminds you of all the parts that are due in your memo. And right now we're about to go on to question presented, and I love my animations and I just have to do it. So as a review, your question presented needed to contain three things and needs to contain three things. One, a description of the specific governing law and its jurisdiction. Two, the precise legal question that you were asked to answer. And three, the most determinative facts that help you answer that question. I need you to remember that the focus of the question presented has to be clear. It's the very first thing on your memo after the heading. So it's the first thing that the reader reads about the case. They haven't read the statement of facts. They don't know anything else. So your question presented has to be clear and all of the essential information must be included in it. So let's see what we have. So there are three things. The first thing is the controlling law and jurisdiction. So this is the example that I showed in class under the Protection of Pupils' Rights Amendment and then the number of the federal statute. It's important that you don't just give the name of the statute or just give the number of the statute, because some people don't know that the Pupil Rights Amendment even was a statute. And if you just gave the number, somebody wouldn't know what it was. For your closed memo, we talked about it in class and agreed that the controlling law and jurisdiction was either Florida negligence law or Florida premises liability law. And this is what I received. Under Florida case law on summary judgment and premises liability cases. That is not Florida negligence law or Florida premises liability law. And all of the cases that you were given in your universe were not summary judgment cases. Then we have under Florida law, which is wrong because it's too broad and encompasses all of Florida's laws. So that doesn't give the reader any information. Under Florida common law regarding negligence, I have said it once, I'll say it 100 times. You do not have to tell the reader whether or not you're using common law. We don't live in a civil law state. Everything that we use is either statute, rules, or common law. Next, the legal question. Remember that the legal question here is specifically the question the attorney asked you to answer. So go back and look at what you were asked to answer, but remember the question was whether or not a potential negligence claim would survive a motion for summary judgment. And here is what I got. Can a court grant a motion for summary judgment when unresolved factual questions exist? That was not the question. Did Walridge Drugstore owe a duty of care to Drew Jackson to prevent the attack in its parking lot? Again, not the question. Here we go. Under Florida premises liability law, would Drew Jackson's negligence claim survive a motion for summary judgment? That's the question that you were specifically asked to answer. And finally, determinative facts. Remember, you don't need to give me all of the facts, but you need to give the facts that make a difference in the answer to the question that you were just asked. So, regarding a person attacking him in the Walridge parking lot is not clear to a reader that knows nothing about this case on why a person attacking in a Walridge parking lot has anything to do with the question and doesn't give them enough information to be able to understand the answer. When Walridge had knowledge of previous criminal activity in the vicinity, do you know that Walridge had knowledge of previous criminal activity in the vicinity? The parking lot was poorly lit. That is a legal conclusion. And no security measures were in place at the time of the attack. Again, and in addition, none of these go to status. All of these go to subsection B and whether or not there was a duty of care. When Mr. Jackson, who went to Walridge to pick up his prescription, is classified as an invitee and Walridge has a duty to provide safe premises. Those are not facts. Those are legal conclusions. Remember that you are not supposed to use legal conclusions in your question presented. Your question presented is supposed to provide the facts that support a legal conclusion. So here we go. This would be a good one. After Mr. Jackson visited Walridge to pick up his monthly prescription, Walridge's pharmacy clerk instructed Mr. Jackson to return in 3 hours, and after Mr. Jackson returned to the parking lot to retrieve money from his car, suffered an attack in Walridge parking lot that had a broken light pole and a history of 911 calls. Those are determinative facts. See the difference? In addition, you were told that, or you were highly encouraged to use the under, does, when format because it's more of a plug and play until you get comfortable with all of the things that need to go in a question presented, and told that you could move on to a weather format, but that it was harder for you because you didn't have to fill in the blanks. And this is what happens when you've never done this before and you don't use a fill in the blank mode. You have something like this. Would Mr. Jackson's potential premises liability claim for negligence survive summary judgment? Good question. Note that there is no controlling jurisdiction or law that precedes it, only the question. If genuine issues of material fact exist about whether Walridge could have reasonably foreseen the attack and whether Walridge took reasonably steps to provide a safe environment for invitees. So again, we have two legal conclusions and no facts because we didn't follow the under, does, when, which would force you to have what you need in your question presented. Want to alert those of you that don't look at the score sheet to know what you are going to be graded on for your open memo and now includes accurate applicable law, accurate legal question, and appropriate relevant facts, does not contain any legal conclusions, is stated objectively, and is readable and uses proper punctuation. The proper punctuation following a question presented would be a question mark. So here is an example of a high-scoring question presented from the final closed memo. Under Florida's negligence law, would Mr. Jackson's negligence claim survive a motion for summary judgment where Mr. Jackson went to Walridge to pick up a prescription and was told by the pharmacy clerk that the medication was not ready and he should return for it in 3 hours. Mr. Jackson left Walridge, ordered food elsewhere, and returned to Walridge to retrieve money from his car to pay for the food. And a random person attacked Mr. Jackson in Walridge parking lot where there was a broken light pole and a Walridge employee had reported a car theft from that parking lot approximately a month before Mr. Jackson's attack. That gives all of the determinative facts. It gives the proper legal question, and it gives the proper controlling jurisdiction and law. Now to brief answer. Again, my favorite slide, because I just like the animation. So you were told that the brief answer needs to start with a straightforward, specific answer to the question, which should be yes or no. Then it needed to have the governing rule, and it needed a brief explanation of why the rule, in conjunction with the facts, leads to the conclusion that you reached. As a reminder for the rubric, starts with a straightforward answer that indicates level of confidence in the conclusion. Again, yes or no, most likely yes, most likely no. Avoids equivocal words like could, may. Is responsive to the question presented. You should answer the question presented directly. I should recognize the question presented's question in your answer. Includes accurate governing rule, and notice the parens around rules. The governing rule that you had in your closed memo was large. Talk about that in a minute. Briefly explains the way in which the application of governing rules to the facts lead to the conclusion. References only those facts that appear in the question presented, is not conclusory, and is stated objectively. So let's see some of what I received. This is an entire brief answer from somebody. Mr. Jackson's claim would survive a motion for summary judgment because during the time the attack took place, he was an invitee because the pharmacy clerk instructed Mr. Jackson to return in 3 hours, and the 5 police calls about crime to the area show material facts if there was foreseeability in the attack and if Walreds breached their duty of care is for a jury to determine. So first, it does not start with a straightforward answer, which would be a yes or a no, period, or a most likely yes, most likely no, period. There is no governing rule in here. And there are very few facts, especially about invitee. Here's another one, a little bit better because we at least have a straightforward answer. Yes, a court would likely deny Walred's motion for summary judgment because Mr. Jackson was an invitee and there are genuine issues of material fact regarding whether Walred breached its duty to protect him from foreseeable harm. Hopefully you see the problem already. We have gone beyond the scope of the memo because we are discussing breach. Mr. Jackson was attacked in a poorly lit parking lot. Again, that's an opinion. Where's the fact? After being instructed to return in 3 hours, reinforcing his invitee status. First, given the documented history of criminal incidents, Walreds had reason to foresee potential harm, but failed to take preventative measures, beep, 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 that would be breach, such as repairing lighting or employing security. These facts create a genuine issue for the jury regarding whether Walreds fulfilled its duty to maintain a safe environment. Another one, most likely yes. Yay, straightforward answer. Sufficient issues of material fact exist for Mr. Jackson's negligence and premises liability claim to withstand Walred's anticipated motion for summary judgment. Now we have part of a governing rule. A negligence claim comprises 4 essential elements, but that's all there is of the governing rule. A court will likely rule that Walred's had a duty to provide a safe environment, particularly given the criminal activity in the area, by failing to repair the broken lights and provide security. Walred's breached this duty, ding, 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 ding. We're in the beyond the scope of the memo again, likely causing Mr. Jackson significant injuries. Thus, the court will likely find material facts remain in dispute and deny Walred's motion. So here's one of the better brief answers from your closed memo. People always say I don't give samples. Here you go. Most likely, yes, a straightforward answer. Now, a negligence claim has 4 elements. Duty arises from the visitor status and premises liability case. Oh, that's the first I've seen that out of any of the brief answers. Florida courts have identified 3 classes of visitors: trespassers, licensees, and invitees. Landowners owe invitees a standard of care that includes protection from foreseeable crimes. That's providing the governing rule. Now, we go into analyzing the issues. Here, a court will likely find that Mr. Jackson was an invitee as a matter of law because the facts are undisputed. Mr. Jackson was an invitee because the Walreds clerk asked him to return in 3 hours, and he was in I lost my space. And he was in the parking lot, which signage indicated was for Walred's customers. Walred's owed Mr. Jackson as its invitee a standard of care, including protection from foreseeable crimes. Look at that, a transition or bridge to the next paragraph. The foreseeability of the attack is likely a question for a jury because of the broken street light and prior car theft in the parking lot. These factors suggest the crime may have been foreseeable, but do not conclusively establish it. So a reasonable jury could still find otherwise. Accordingly, while a court is likely to find Mr. Jackson was an invitee, the facts do not conclusively establish the crime's foreseeability, leaving questions for the trier of fact. And now we answer the question presented. Accordingly, a court would likely find that Mr. Jackson's negligence claim would survive a motion for summary judgment. I hope you see the difference in them. I hope you realize that not all brief answers are a single paragraph. I hope you realize what a governing rule is. I hope that all of this helps for you to prepare your question presented in brief answer for your open memo. Remember to never stop learning. This was your very first time doing this for a grade. Breathe, and I will talk to everybody soon.